Yo, man, you killed 6 people?
Huh?
Did you kill 6 people, sir?
No.
Huh?
13. They just...
You killed 13?
13 people.
Okay. Why'd you do it?
The 7. Oh, my.
Breaking today, the man accused of Mississippi's worst family massacre in state history just entered a courtroom and pleaded not guilty to 11 felony charges, including 3 counts of capital murder. Derica Moore, the 24-year-old at the center of this horrifying case, stood before the judge on January 13, 2026, just days after allegedly taking the lives of 6 people in a single night, including his own father, brother, uncle, and a 7-year-old child. The district attorney has already announced they're seeking the death penalty.
All of our hearts and prayers go out to the victims and the survivors of this really tragic, horrific spree of murders last night. And as the sheriff said, these charges are going to be upgraded to capital murder. They're going to probably be more than 1 count, to be honest with you. And I do want to say this. I talked to Trina Davidson this morning, and she asked me, I didn't suggest it, she asked me, could she be the special prosecutor on this case? It worked very well, and it's working very well with the Oasis shooting, and we're really making great progress to going to trial on that case.
Bond was denied. A mental health evaluation has been ordered. And now, everyone is asking the same question. What defense could possibly justify what happened on the night of January 9th, 2026? This isn't just another true crime story. This is a case that has shaken an entire state, left experienced law enforcement officers struggling to find words, and forced us all to confront something deeply unsettling about the nature of violence within families. Because, here's what makes this case so disturbing. Derica Moore had no criminal record, 0 arrests, no history of violence, no red flags that anyone in his community or law enforcement had noticed. He wasn't on anyone's radar. And then, in the span of less than 5 hours, he allegedly went to 3 separate locations and methodically ended the lives of 6 people, 4 of whom were his own blood relatives. The victims weren't strangers, they were family. Glenn Moore, 67 years old, Derica's father. Quentin Moore, 33, his brother. Willie Ed Guines, 55, his uncle. Michaelia Guines, just 7 years old, his second cousin. And Barry Bradley and Samuel Bradley, brothers from Columbus, one of whom was a pastor at a church where Derica's family worshipped. 6 lives, 3 locations. One devastating night that has left the rural community of Cedar Bluff, Mississippi, asking how something like this could happen in their quiet corner of the world. If you're just hearing about this case now, let me bring you up to speed, because the timeline of what allegedly happened is as methodical as it is horrifying, and understanding that timeline is crucial to understanding what's about to unfold in the courtroom. It was Friday evening, January 9th, 2026. The sun had already set over Cedar Bluff, a small, unincorporated community in western Clay County, Mississippi. This is the kind of place where families have lived for generations, where everyone knows everyone, where church on Sunday is a given. It's not the kind of place where mass violence happens. Until that fateful night. At approximately 6:56 p.m., Clay County's emergency dispatch received a frantic call reporting gunshot victims at 299 Blake Road in Cedar Bluff. Deputies arrived at the scene at 7:03 p.m., but what they didn't know yet was that this call was actually the second location in a killing spree that had already begun. The real starting point was a mobile home on David Hill Road, just a few miles away. Inside that mobile home, investigators would discover 3 men, all with fatal wounds to the head. Glenn Moore, 67, the father. Quentin Moore, 33, the brother. Willie Ed Guines, 55, the uncle. All 3 were related to Derica Moore. All 3 were found deceased when deputies processed the scene. According to Sheriff Eddie Scott, evidence suggests this was where the violence began.
Derica Moore, as you see here on the screen to my left, black male age 24, allegedly shot and killed Glenn Moore, age 67, Willie Ed Guines, 55, and Quentin Moore, 33, at a residence located at 123 David Hill, Cedar Bluff, Mississippi. Upon arrival, deputies discovered the gunshot wounds to the head. The men were pronounced deceased by Clay County Medical Examiner. Moore then allegedly stole a Ford F-150, aluminum in color, belonging to the deceased brother, Quentin Moore. It is believed that Derek Moore then traveled to 299 Blake Road, where we initially got the...
This was location 1. After allegedly taking the lives of his father, brother, and uncle, investigators believe Derek Moore took his deceased brother's Ford F-150 pickup truck, a light-colored aluminum vehicle, and drove away from the scene of his first alleged crimes. He didn't flee the area. He didn't try to escape. Instead, he drove to Blake Road, to the home of his cousin. At the Blake Road residence, things became even more incomprehensible. According to Sheriff Scott's press conference on January 11, 2026, Moore forced his way into the home where his cousin, the mother of 3 children, was present. Inside that house were 3 young kids and their mother. Moore was armed with a handgun. Witnesses reported that he attempted to commit an assault on the adult woman in the home, his cousin, and then, in front of witnesses, including the child's own mother and siblings, he allegedly placed a weapon to the head of 7-year-old Makilia Guines, his second cousin, and took her life. Let that sink in for a moment. A 7-year-old child, in front of her mother, in front of her siblings. Sheriff Eddie Scott, a man with nearly 30 years of law enforcement experience, stood before reporters and cameras and said something that still echoes, "I don't know what kind of motive you could have to take the life of a 7-year-old. There's just none out there that you can explain to me why this would happen." But the horror at Blake Road didn't end there. According to witness statements provided to investigators, after Makilia was gone, Moore allegedly placed a weapon against the head of another child in that home, a child even younger than 7 years old. And for reasons that investigators still cannot explain, whether the weapon misfired or whether Moore chose not to pull the trigger, that second child survived. Sheriff Scott called it a blessing amid unspeakable tragedy. 3 children were in that house. 1 lost her life. Another came within a trigger pull of the same fate. After fleeing the Blake Road residence, still driving his deceased brother's stolen truck, Moore allegedly traveled to a 3rd location, 1965 Siloam Griffin Road. This address is the site of the Apostolic Church of the Lord Jesus, a small white frame church in the Cedar Bluff area. On the church property was a residence where the pastor Barry Bradley and his brother Samuel Bradley stayed on weekends when they came from Columbus to serve the congregation. Some of Moore's family members attended this church. The pastor was known to him. Moore allegedly broke into that residence. Inside, investigators found the Bradley brothers, both with fatal wounds to the head. Barry Bradley, a man dedicated to faith and service. Samuel Bradley, his brother. 2 more lives extinguished. And after allegedly taking their lives, Moore stole one of their vehicles and fled the scene once again. By this point, law enforcement from multiple agencies had flooded Clay County. The Mississippi Highway Patrol, the U.S. Marshals, the Mississippi Bureau of Investigation, the Mississippi Bureau of Narcotics, local officers. Dozens of law enforcement personnel converged on the area, setting up safety checkpoints and roadblocks throughout the rural community. If you moved through western Clay County that night, you were going through a checkpoint. At 11:24 p.m., less than 5 hours after the first emergency call, Derek Moore drove through one of those checkpoints at the intersection of Pine Grove Road and Joe Myers Road. He was driving the vehicle allegedly stolen from the church residence. Officers stopped him. Inside the vehicle, they found both a rifle and a handgun. Derek Moore was taken into custody without incident. 6 people were dead, 3 separate locations, multiple stolen vehicles, and a community was left reeling, trying to make sense of the senseless. Now here's where this case takes a turn that has everyone watching closely, because in the days following Moore's arrest, certain details have emerged that are shaping the legal battle to come. And the central question that's dominating every conversation about this case is this: what possible defense could Derek Moore's legal team present? There are really only a handful of potential defense strategies in a case like this, and each one comes with significant challenges. Let's break them down, because understanding these possibilities is crucial to understanding what's likely to happen as this case moves toward trial. The first possibility, and perhaps the most likely given the court's order for a mental health evaluation, is an insanity defense or a claim of severe mental illness. Now, before we go further, we need to understand what an insanity defense actually means in legal terms, because it's often misunderstood. An insanity defense doesn't mean the defendant was angry or upset or even deeply disturbed. It means that at the time of the alleged crimes, the defendant was so severely mentally ill that they could not understand the nature of their actions, or could not distinguish right from wrong. In Mississippi, the legal standard for insanity is based on what's called the Monoton Rule, which essentially asks, did the defendant, at the time of the act, know what they were doing, and did they know it was wrong? If a defendant can prove they didn't understand their actions or couldn't tell right from wrong due to a severe mental disease or defect, they may be found not guilty by reason of insanity. However, this doesn't mean they go free. If successful, they're typically committed to a psychiatric facility, potentially for life. Here's why a mental illness defense might be on the table for Moore. First, he had absolutely no criminal history. Online court records in Clay County show 0 prior arrests or charges. Sheriff Eddie Scott explicitly stated that Moore was not on our radar and that there had been no reports, nothing prior leading up to this. Family members interviewed at the scene told investigators they never would have believed Moore capable of something like this.
It has been tough on my family, but God. We understand that this was not Dorico. We are a close-knit family. This was not him. This was an attack on our family, but it was not Dorico, and we understand that. Mental health is real.
In other words, from the outside, there were no warning signs, no pattern of escalating violence, no history of criminal behavior. When someone with a completely clean record suddenly commits extreme violence, especially against their own family, mental health professionals and legal experts often look at the possibility of an acute psychotic break or the sudden onset of severe mental illness. Conditions like schizophrenia, which often first manifest in young adults, particularly men in their early to mid-20s, can sometimes appear suddenly and with devastating consequences. Schizophrenia can involve paranoid delusions, hallucinations, and severely distorted thinking. A person experiencing a psychotic episode might believe completely irrational things, like their family members are part of a conspiracy against them or that they're in imminent danger and must act to protect themselves. The fact that Moore is 24 years old is significant here. This is precisely the age range when serious mental illnesses like schizophrenia tend to emerge in men. If Moore's defense team pursues this angle, they'll likely bring in mental health experts who will conduct extensive evaluations, review his medical and personal history, interview family members about any changes in his behavior leading up to January 9th, and potentially testify that Moore was experiencing a psychotic break that rendered him incapable of understanding his actions. But here's the problem with an insanity defense in this case. The timeline and the nature of the alleged crimes suggest a level of planning and awareness that could undermine a mental illness claim. Moore allegedly went to 3 separate locations. He allegedly stole vehicles after the incidents to facilitate his movements. He drove from place to place. He allegedly broke into homes at 2 of the locations. These actions suggest someone who understands cause and effect, who can navigate from one place to another, who can operate vehicles and make decisions about where to go next. That level of functioning makes it harder to argue that someone was so mentally ill they didn't understand what they were doing. Additionally, there's the attempted assault at Blake Road. While I won't go into graphic details out of respect for the victims and to maintain the educational nature of this content, the fact that Moore allegedly attempted a specific act suggests intent and awareness, not a complete break from reality. Psychotic individuals can sometimes engage in violent behavior, but the pattern here, the movement between locations, the targeting of specific individuals, the operational capability to drive and break into homes, all of these factors make a pure insanity defense extremely challenging. Another potential angle, though far less likely given the facts we know, is self-defense. Now, I know what you're thinking. How could this possibly be self-defense? 6 people are gone, including a young child. But in the American legal system, defendants have the right to present a defense, and we have to consider all possibilities, no matter how unlikely they seem. A self-defense claim would require Moore's legal team to argue that he reasonably believed he was in imminent danger and that the force used was necessary to protect himself. This is an extraordinarily high bar to meet in this case. For self-defense to be viable, there typically needs to be evidence of an immediate threat, evidence that the defendant had no reasonable means of escape, and evidence that the level of force used was proportional to the threat faced. In this case, we're talking about 6 individuals across 3 locations. Even if, and this is purely hypothetical, there was some kind of confrontation at the first location on David Hill Road, a self-defense claim would be virtually impossible to extend to the other locations. Once someone leaves a scene of confrontation, drives to a different location, and allegedly harms additional people, the self-defense argument collapses. You can't claim self-defense when you're the one initiating contact and entering other people's homes. Moreover, there is absolutely no conceivable self-defense justification for what happened to 7-year-old Makeelia Gweens. A child cannot pose the kind of threat that would justify the use of force. This alone makes a self-defense strategy almost impossible to pursue credibly. There's a third possibility that's worth mentioning, though it's less a defense and more a mitigating factor, that the defense might present during sentencing if Moore is convicted. That's the idea of diminished capacity or extreme emotional disturbance. This doesn't argue that Moore didn't commit the acts or that he was legally insane, but rather that there were circumstances or mental states that, while not excusing the behavior, might explain it and potentially reduce the severity of the punishment. For example, Moore's defense team might investigate whether he experienced severe trauma, whether there was a history of conflict or mistreatment within the family that had been building for years, whether there were substance abuse issues, or whether some triggering event occurred on January 9th that sent him into an extreme state of rage or distress. The goal here wouldn't be to get Moore acquitted, but rather to potentially avoid the death penalty by presenting mitigating factors that a jury might consider during the sentencing phase. District Attorney Scott Colum has already made it crystal clear that his office intends to seek the death penalty. During the press conference on January 11th, Colum stated, "If he's eligible, we're going to go for the death penalty and let a jury decide his fate." He went on to say, 6 people, 1 night, several different scenes. You've heard the allegations. They're about as bad as it gets.
Yeah, I'm like with the sheriff. Somebody killing their dad, their brother, their uncle in a short period of time, a 7-year-old who's related to him. I mean, I can't get an answer to that one. There's no, it's hard to preempt that without some previous reports or warnings or something to law enforcement. Like I said, if it is eligible, there are some legal stuff we got to go through. But if it's eligible, you can't have a case like this and not seek the highest punishment under Mississippi law. It's just, if you don't do it in this situation, then basically you're not going to do it. So this is just fits that criteria where it has to happen if eligible.
How many capital murder charges are you going after?
Well, Sheriff and I were talking about it.
Colum made a decision that's actually quite unusual. Typically, prosecutors consult with the families of victims before making the decision to pursue capital punishment. But in this case, Colum announced the decision to seek death almost immediately, even before consulting with the families. As he explained during the press conference, typically I would consult with the victims and wait down the line, but there's got to be some cases just that they've got to get the worst punishment. 6 people, 1 night, several different scenes. That tells you everything you need to know about how the prosecution views the severity of these alleged crimes. If you're still with me at this point, I need you to do something. Drop a comment right now and let me know where you're watching from. Are you in Mississippi? Are you following this case from across the country? And if you've made it this far, type "justice for the victims" in the comments. Now, let's talk about what makes this case eligible for capital punishment, because not every case involving loss of life qualifies for the death penalty. In Mississippi, there are specific aggravating factors that must be present for prosecutors to seek capital punishment. Looking at the charges Moore is facing and the facts of the case, there are multiple aggravating factors that the prosecution will likely argue make this a death penalty case. First, Moore is charged with 3 counts of capital murder. In Mississippi, capital murder is a specific charge that applies when certain circumstances are present. One of those circumstances is taking the lives of 3 or more people in a single course of conduct. The alleged incidents on January 9th clearly meet that threshold. Moore is accused of causing the passing of 6 individuals in a single evening across 3 locations. That alone qualifies as capital murder under Mississippi law. Second, one of the victims was a child. Mississippi law specifically includes the harming of a child under certain circumstances as a capital offense. The fact that 7-year-old Makelia Goins lost her life in this incident provides another basis for capital murder charges. The loss of a child, particularly one so young and in such horrific circumstances, is something that juries find especially devastating and often weighs heavily in capital sentencing decisions. Third, the alleged crimes involved a burglary. According to Sheriff Scott, Moore forced his way into homes at both Blake Road and Salome Griffin Road. When a loss of life occurs during the commission of certain felonies, including burglary, that elevates the charge to capital murder. The prosecution will argue that Moore broke into his cousin's home and broke into the church residence, and that people lost their lives during those break-ins. Fourth, there's the attempted assault at Blake Road. While the specifics have been handled sensitively in official statements, the fact that Moore allegedly attempted this act while armed adds another layer of severity to the charges. This demonstrates not just violence, but a pattern of escalating criminal behavior during the same incident. When you add all of these factors together, it's clear why District Attorney Colum moved so quickly to announce the decision to seek the death penalty. This case has virtually every aggravating factor that makes prosecutors pursue capital punishment. Multiple victims, a child victim, felonies committed during the incident, the targeting of family members, the use of firearms, the methodical nature of traveling between locations. All of these elements combine to create what prosecutors would call one of the most aggravating cases they've ever seen. But here's what we need to understand about death penalty cases. They're extraordinarily complex and lengthy. Even with a case that seems as clear-cut as this one appears to be based on the evidence described by law enforcement, the legal process will likely take years. There will be extensive pretrial motions. There will be battles over evidence. There will be mental health evaluations, which the judge has already ordered. There will be attempts by the defense to have certain evidence excluded, or to have the case moved to a different venue due to pretrial publicity. If the case goes to trial, it will likely be bifurcated, meaning there will be 2 phases. First, the guilt phase, where the jury determines whether Moore is guilty of the charges. If convicted, there would then be a sentencing phase, where the same jury would hear arguments about whether Moore should receive the death penalty or life in prison, without the possibility of parole. During that sentencing phase, the prosecution would present all of those aggravating factors we just discussed. The defense would present any mitigating factors they can find, things like Moore's age, his lack of prior criminal history, any evidence of mental illness or trauma, anything that might make a jury hesitate before imposing a death sentence. And here's something that might surprise you. Even in cases with overwhelming evidence and multiple aggravating factors, juries are often reluctant to impose the death penalty. It's one thing to convict someone of terrible crimes. It's another thing entirely to be the person who votes to end another human being's life. Defense attorneys know this, and they will focus heavily on humanizing Moore, on presenting him as more than just the person who allegedly committed these acts in an effort to save his life. So, where does that leave us right now? As of January 13, 2026, Derica Moore has entered a not guilty plea to all 11 charges against him. Those charges include 3 counts of capital murder, 3 counts of first-degree murder, attempted harm of a child, attempted assault, multiple counts of burglary, and vehicle theft. He's being held without bond at the Clay County Jail in West Point, Mississippi. Judge Jim Kitchens has ordered a mental health evaluation, which suggests that the court is already anticipating that mental health will be a significant factor in this case. The prosecution team is being led by Special Prosecutor Trina Davidson, who was specifically requested for this case because of her work on another high-profile incident in the area. District Attorney Colum spoke highly of Davidson during the press conference, noting that she asked to be assigned to this case because it was so personal to her. Having a prosecutor who is personally invested in seeking justice can make a significant difference in how aggressively a case is pursued. The investigation is ongoing. Sheriff Eddie Scott emphasized multiple times during his press conference that they were still in the preliminary stages of processing 4 separate crime scenes. Autopsies have likely been conducted to establish the exact causes of passing. Witness statements are being documented and verified. Digital evidence, like cell phone records and any surveillance footage from the areas, is being analyzed. One of the questions investigators are still working to answer is the motive. Why did this happen? What could possibly drive someone with no history of violence to allegedly take the lives of 6 people, including family members and a child, in a single night? Sheriff Scott was remarkably candid about this during his press conference. "I don't know what his state of mind was, what was going on with him. That's part of the investigation right now," Scott said. He later added, "We may never know the motive. I'm hoping that we'll find out, but it would have to be something drastic to commit this type of crime." The lack of a clear motive is actually one of the most unsettling aspects of this case. As humans, we want things to make sense. We want to understand why terrible things happen. We look for patterns, for warning signs, for explanations. But sometimes, especially in cases involving potential severe mental illness, there isn't a motive that makes sense to rational minds. Sometimes the reason is that someone's brain was malfunctioning so severely that they perceived reality in a fundamentally distorted way. Sometimes there is no reason that would satisfy our need for understanding. What we do know is the impact this has had on the community and on the surviving family members. During his press conference, Sheriff Scott spoke about the overwhelming grief he witnessed when he talked to family members on the night of January 9th. "It's just right now overwhelming grief," Scott said. "It's hard to describe. I know how I felt just to be there looking at these family members, trying to first of all grieve the loss of their loved ones, and then finding out who it was that committed this, another family member. I mean, it was overwhelming to everybody. Think about what that means for the surviving family members. The mother who watched her daughter lose her life. The other children who were present in that home, who will carry the trauma of what they witnessed for the rest of their lives. The extended family members who lost Glenn, Quentin, Willie, Makilia, Barry, and Samuel. And now they have to grapple with the fact that the person accused of taking their loved ones is also their family member. Derica is a son, a nephew, a cousin to these same people who are grieving. This is the unique horror of familial violence. In cases where the perpetrator is a stranger or even an acquaintance, there's a clear distinction between victim and offender. But when the alleged offender is family, that line becomes impossibly blurred. How do you grieve? Your father, brother, uncle, and little cousin while also processing that your own family member allegedly took their lives? How do you support the prosecution of someone who shares your blood? How do you reconcile love, grief, betrayal, and loss all at once? Sheriff Scott mentioned that he could barely have any conversation with family members beyond offering prayers. What do you say? There are no words that can make sense of this kind of tragedy. There's no comfort that can be offered that doesn't feel hollow in the face of such overwhelming loss. And let's not forget the broader community impact. Cedar Bluff is a small, rural community. The kind of place where families have deep roots, where people know each other, where your neighbors are often your relatives or people you grew up with. This isn't a big city where anonymity is possible. This is a tight-knit community, and when something like this happens, it shatters the sense of safety and trust that small communities rely on. Sheriff Scott acknowledged this when he talked about how the incident has really shaken our community. He noted that local churches were coming together, organizing prayer groups, trying to support the affected families. In small communities like this, collective trauma is real. Even people who didn't know the victims personally are affected because they know someone who knew them, or they worship at the same church, or their kids went to school together. The ripples of this tragedy extend far beyond the immediate family. Now, I want to address something that's come up repeatedly in discussions about this case, both in news coverage and in public forums. Multiple people have noted that this is the second mass casualty incident in Clay County in less than 2 years. During the press conference, a reporter asked Sheriff Scott about this, and his response is worth considering. "Unfortunately, it's happened all over the country," Scott said. "We're put in a position where we have to be reactive. If we've got people on our radar that we can deal with on the front side. But when you got individuals that just show up and start engaging in violence because they have disagreements or they don't like something for whatever reason, it's hard for law enforcement to stay ahead of that." Scott went on to say, "In this case, right here, again, this is reactive for us because this guy was not on our radar. These are family members that he went after, and nobody has reported anything to us." He emphasized the challenge of preventing violence when there are no prior warnings, no history of concerning behavior, nothing that would put someone on law enforcement's radar. This raises difficult questions about violence prevention. What could have been done differently? Were there warning signs that were missed? Should there have been interventions that could have prevented this? The honest answer is that we don't know yet. The investigation is still ongoing. We don't know if there were private family conflicts that never became public. We don't know if Moore was struggling with mental health issues that he kept hidden. We don't know if there were changes in his behavior that people noticed but didn't report. One of the harsh realities of cases like this is that sometimes, even with the benefit of hindsight, there aren't clear red flags that would have prompted intervention. Not every person who commits violence has a history of violence. Not every person who is suffering mentally reaches out for help or exhibits obvious symptoms, and our society doesn't have systems in place to identify and help everyone who might be in crisis. Sheriff Scott also addressed the issue of firearm access during his press conference. A reporter asked what conversations this tragedy should force about violence prevention, and Scott gave a candid response. "It's a problem all across the country, and everybody's trying to come up with a suitable answer for it."
Anybody out in the public that has any additional information, to please contact the Sheriff's Office or the Golden Triangle Crime Stoppers with this. We want to say that we all lift our hearts in prayer for the victims and families. Again, this is really, really shaking our community. And for me, almost 30 years in this is one of the toughest ones we had to work. So again, our job right now is to thoroughly investigate, make sure that we get our district attorney's office everything that they need to prosecute. At this time, I'm going to turn it over to our district attorney, Mr. Scott Cologne.
"As of yet, nobody has," Scott said. He mentioned that they were investigating where Moore obtained the weapons, whether they belonged to him, whether they belonged to someone else, whether they were stolen. "Firearms are readily accessible to anybody," Scott noted. "This is a politically fraught topic, but it's one we can't ignore when discussing cases like this." Moore was reportedly armed with both a rifle and a handgun when he was apprehended. In Mississippi, as in many rural areas, firearms are common. Many households have guns for hunting, for protection, for sport. But the flip side of easy access to firearms is that when someone does experience a mental health crisis or decides to engage in violence, the tools to cause mass casualties are readily available. I'm not here to make political arguments about gun rights or gun control. What I am here to do is present the facts of this case and acknowledge the realities. The reality is that firearms significantly increase the lethality of violent incidents. The reality is that Moore allegedly caused the passing of 6 people in a matter of hours, something that would have been far more difficult without firearm access. The reality is that investigators are still determining how Moore obtained the weapons he allegedly used, and that information may be relevant to understanding how this tragedy unfolded. So what happens next in the legal proceedings? The preliminary hearing that was scheduled for January 13, 2026 has now taken place, with Moore entering his not guilty plea and being denied bond. The next major step will be the mental health evaluation that Judge Kitchens has ordered. This evaluation will likely take several weeks or even months. Mental health experts will need to interview Moore extensively, review any available medical and psychiatric records, potentially interview family members and people who knew him, and conduct various psychological tests and assessments. The results of that evaluation will be crucial in shaping the defense strategy. If the evaluation finds evidence of severe mental illness, particularly if it suggests Moore may have been experiencing psychosis or a significant mental break at the time of the alleged crimes, the defense will almost certainly attempt to use that as the foundation of their case. They might argue for a not guilty by reason of insanity verdict, or they might acknowledge guilt, but argue for a lesser sentence based on diminished capacity. If the evaluation doesn't find evidence of severe mental illness, or if it concludes that Moore was capable of understanding his actions and distinguishing right from wrong, the defense will have to pursue other strategies. This might include investigating potential mitigating factors in Moore's background, looking for evidence of trauma or abuse, or simply focusing on trying to spare Moore from the death penalty during the sentencing phase if he's convicted. Meanwhile, the prosecution will likely be building their case. They'll be working with the Mississippi Crime Lab to analyze all physical evidence. They'll be documenting the crime scenes, collecting witness statements, establishing a clear timeline of events, and preparing to present a comprehensive case to a jury. District Attorney Collum and Special Prosecutor Trina Davidson will be coordinating with Sheriff Scott's investigators to ensure every piece of evidence is properly documented and preserved. One aspect of this case that could become contentious is the question of where the trial will be held. In high-profile cases with significant media coverage, defense attorneys often file motions for a change of venue, arguing that pretrial publicity has made it impossible for their client to receive a fair trial in the community where the alleged crimes occurred. Given the extensive news coverage this case has received, both locally and nationally, and given the small size of Clay County's population, it's quite possible that Moore's defense team will argue that he cannot get a fair trial in Clay County and request that the trial be moved to another jurisdiction. Prosecutors typically oppose such motions, arguing that media coverage is widespread and that moving the trial won't necessarily result in finding jurors who haven't heard about the case. They also argue that victims' families and the community have a right to see justice served in their own county. But judges do sometimes grant venue changes in extremely high-profile cases, so this is something to watch for in the coming months. Another legal battle that's likely to emerge is over what evidence can be presented at trial. The defense will almost certainly file motions to suppress certain evidence, arguing that it was obtained improperly or that its prejudicial value outweighs its probative value. For example, if there were any issues with how Moore was questioned after his arrest, the defense might try to have any statements he made excluded from trial. If there were any issues with how the crime scenes were processed or how evidence was collected, the defense might challenge the admissibility of that evidence. The prosecution will also have to be very careful about what evidence they present and how they present it. In death penalty cases, there's always a concern about overly prejudicial evidence inflaming the jury's emotions to the point where they can't make a rational decision. At the same time, the prosecution needs to present a complete picture of what allegedly happened, including the impact on victims. It's a delicate balance, and experienced prosecutors like Collum and Davidson know how to walk that line. One question that many people have been asking is whether Moore might consider a plea deal. In death penalty cases, it's actually quite common for prosecutors to offer plea agreements that take the death penalty off the table in exchange for a guilty plea and a sentence of life without parole. This saves the state the enormous expense of a capital trial, spares the victims' families the trauma of a lengthy trial, and ensures that the defendant will never be free again. However, given District Attorney Collum's emphatic statements about seeking the death penalty and his characterization of this as a case that deserves the worst punishment, it's unclear whether the prosecution would be willing to offer such a deal. Collum seems determined to let a jury decide Moore's fate. That said, plea negotiations often happen behind the scenes, and it's possible that as the case progresses, if the defense presents compelling mitigating evidence, or if there are concerns about the strength of certain aspects of the case, the prosecution might reconsider. From the defense's perspective, a plea deal that avoids the death penalty might be attractive, particularly if the mental health evaluation doesn't provide a strong basis for an insanity defense. Life without parole is still an incredibly harsh sentence, but it's better than execution. However, Moore would have to admit guilt, and his attorneys would have to convince him that a plea is in his best interest. Given that Moore has pleaded not guilty, it appears that at least for now, he's not interested in accepting responsibility or negotiating a plea. Let's talk about some of the unanswered questions that still linger in this case, because there's so much we still don't know. First and foremost, what was the motive? Why did this happen? Investigators have interviewed Moore, but they haven't publicly disclosed what, if anything, he's told them about why he allegedly did this. Was there a triggering event on January 9th? Was there a confrontation at the first location that escalated? Had there been building tensions within the family that finally exploded? Or was this truly a case of sudden mental illness manifesting in the most horrific way possible? Another question. What was Moore's mental state in the days and weeks leading up to January 9th? Had people noticed changes in his behavior? Was he acting differently? Saying strange things? Seeming paranoid or distressed? Or did he appear completely normal right up until the violence began? The mental health evaluation may provide some answers, but investigators are also likely interviewing friends, extended family members, co-workers if he was employed, anyone who might be able to shed light on Moore's state of mind before that night. There's also the question of the weapons. Where did Moore get the rifle and handgun? Were they his? Did they belong to family members? Were they stolen? If they belonged to someone else, were they properly secured, or did Moore have easy access to them? These questions are relevant not just to this case, but to broader discussions about firearm safety and storage, particularly in homes where there might be concerns about mental health. What about substance use? Sheriff Scott mentioned during his press conference that drugs can contribute to acts of violence. Was Moore under the influence of any substances on January 9th? Did he have a history of drug or alcohol use? Toxicology reports from the time of his arrest would show whether he had anything in his system, but information about any history of substance abuse would come from interviews with people who knew him. As we look at the bigger picture, this case forces us to confront some uncomfortable truths about violence in America, about family dynamics, and about the warning signs we might miss. The fact that Moore had no criminal history, no documented history of violence, nothing that put him on law enforcement's radar, is both unusual and deeply unsettling. It suggests that even in our most intimate relationships, within our own families, we may not truly know what someone is capable of. Family violence is, unfortunately, far more common than many people realize. According to the Bureau of Justice Statistics, a significant portion of violent crimes are committed by someone the victim knows, often a family member or intimate partner. The difference with this case is the scale and the severity. Most family violence doesn't result in 6 people losing their lives in a single night. But the underlying dynamics, the hidden tensions, the private conflicts that exist within families, those are present in countless homes across this country. One of the challenges in preventing family violence is that it often happens behind closed doors. Neighbors don't see it. Friends might suspect something is wrong, but don't want to interfere. Family members might normalize dysfunction because it's all they've ever known. And victims of family violence often don't report it because of shame, fear, love for the abuser, or a belief that family problems should stay in the family. I'm not suggesting that there was a history of family violence in Moore's family. We don't know that. What I am saying is that this case, as extreme as it is, exists on a continuum of family violence that affects millions of Americans. And if we're going to have any hope of preventing future tragedies, we need to be willing to have honest conversations about what happens within families, about the resources people need to address conflict and trauma, and about the importance of taking concerns seriously even when everything appears fine on the surface. There's also the mental health component that we can't ignore. If it turns out that Moore was experiencing a severe mental health crisis, that raises questions about access to mental health care, particularly in rural areas like Clay County. Mental health services are often limited in rural communities. There may be few psychiatrists or therapists available. The stigma around seeking mental health treatment can be even stronger in small, tight-knit communities where everyone knows everyone. And young men in particular are often reluctant to seek help for mental health issues, due to cultural expectations about masculinity and self-reliance. As this case moves forward, we're going to learn more about Derek Moore, about his background, about what might have led to this night of alleged violence. The mental health evaluation will provide insights. The trial, if it happens, will present evidence and testimony that may answer some of our questions. But we also have to prepare for the possibility that some things will never make sense, that some questions won't have satisfying answers. The reality is that human behavior, particularly in cases involving potential mental illness, doesn't always fit into neat explanations. Sometimes there isn't a clear triggering event. Sometimes there isn't a history of abuse or trauma that explains the violence. Sometimes a person's brain malfunctions in ways that lead to horrific outcomes, and no amount of investigation or analysis can fully explain why. What we can do is honor the victims by telling their stories, by refusing to let them be reduced to statistics or forgotten in the flood of daily news. Glenn Moore, 67 years old, a father and grandfather. Quentin Moore, 33, a brother. Willie Ed Guines, 55, an uncle. Michaelia Guines, just 7 years old, a child who should be growing up, learning, playing, living her life. Barry Bradley, a pastor dedicated to serving his community. Samuel Bradley, his brother. 6 lives, 6 stories, families forever changed. The survivors of this tragedy, particularly the children who witnessed the violence at Blake Road, will need extensive support. Trauma of this magnitude doesn't just go away. It requires professional intervention, therapy, support systems, and time. The Clay County community will also need to heal, and that healing process will likely take years. Sheriff Scott mentioned that churches were coming together, that prayer groups were forming, that the community was rallying to support the affected families. That kind of collective response is crucial in the aftermath of tragedy. What happens in the courtroom matters. Justice for the victims matters. Accountability matters. But so does prevention. So does intervention. So does creating a society where people in crisis have access to help before tragedy strikes. The Derek Moore case will likely remain in the news for months or even years as it progresses through the legal system. There will be more court hearings, more revelations, more developments. The mental health evaluation results will eventually be made public, at least in part. The trial, if it happens, will present testimony and evidence that may shed new light on what happened and why. If Moore is convicted, the sentencing phase will present arguments about whether he should face execution or spend the rest of his life in prison. If you've watched this entire video, I want to thank you for your attention and your commitment to understanding this case fully. These stories are difficult, they're disturbing, they're heartbreaking, but they're important. Drop a comment below and let me know your thoughts. What questions do you still have about this case? What aspects of the legal proceedings are you most interested in following? And please, share this content with others who care about criminal justice. Subscribe to this channel for continued coverage as this case develops, and hit the notification bell so you don't miss any updates. This story is far from over. The legal battle is just beginning. The victims' families are still grieving. The community is still reeling. And Derek Moore sits in the Clay County Jail, awaiting a trial that will determine whether he spends the rest of his life in prison or faces execution for the events of January 9, 2026.